we are in the Child Rights Week, and it is the last day. So we all are the ambassadors for child rights. So let's look why this law came into force. POCSO Act came into force in 2012. Why did this law come into force? When we from an Indian background, we always were trying to say that we have the best culture, we have the best support system. The children are well protected in an Indian situation or in the Indian community. But still, we had to hurriedly pass out the POCSO law, and we all are now debating, even almost 9 years after the law came into force. Still, we are debating on it. So that's the situation what we are, because POCSO is a special law, and it has got a sort of a wide ramifications. The POCSO law came into force because in 2007 there was a research study by the Women and Child Department and a couple of NGOs. The results which came out were very alarming. It brought out saying that every second child in their lifetime was sexually abused. So this was something very difficult to accept when the statistics were brought out, that 53% of Indian children were once in their lifetime being sexually abused. And more difficult to accept was more than 71% of those abusers were the people whom the child had known or the child had trusted. So in this context, so the POCSO law got into force or was brought in by the government. Now, how is that connected to our case? So if the parents are insisting on something, so should we toe in line with the parents, or should we be the ambassadors of child rights and see the best interests of the child? I'm sure we all agree saying that we should be the ambassadors for child rights and should work for the best interests of the child always. So in this scenario, why is the child not agreeing to get the medical examination? So it's not mere consent. So we need to give an informed consent or an informed refusal. So in this scenario, instead of asking ourselves or our subordinate to put a mere signature on the dotted column, so we need to spend in time for seeking this consent, providing all the information. Why is this medical examination needed? Many a time as doctors, we feel that this medical examination is only needed for evidence collection. It's wrong. We have now recognized that there are therapeutic interests, there are health consequences post sexual violence, and that takes the precedence. And we should not lose any opportunity for providing therapeutic care to a victim of sexual violence. So in this scenario also, we need to counsel the child the need for the medical examination, what would be the advantages of getting an examination in terms of providing therapeutic care to the victim, as well as trying to look at if the evidence is collected, how that helps in the criminal investigation. And in spite of all your efforts of providing information, if still the child refuses to get examined, so that is when you document the informed refusal. Now, somebody points out saying that no, we have certain policies or medical legal code which the state has passed. Now, should we toe in line with wherein it insists saying that the consent only operates at 18 years? If you look at that approach of saying that a child less than 18 years doesn't have an agency to consent for any medical examination, we may lose upon all those cases. though incest is not a separate crime in an Indian context, but it is punishable under the existing rape and sexual assault situation. And the research evidence points out that more than 71% of the people who are the abusers are the trusted or the known people of the child. So if you look out the myth of the family being the best support system, so if 71% of the abusers are within the family, so that means if you toe in line with only the natural guardian, we may not be acting in the best interest of the child in 71% of the cases. So when the law provides a child an agency to consent or refuse a situation, so shouldn't we doctors act as a best ambassadors of custodians of child rights and always act in the best interest of the children? So that's the scenario. I hope I have clarified all possible issues which are connected to this case. And if there are anything else, we can come back on this case again towards the end of this presentation. I hope that's fine, and we move ahead. Next, we have a 10-year-old victim of sexual assault who is brought by parents to the hospital for treatment. Father is suspicious of your procedures. Victim is afraid whenever she sees her father. So what should you do, and whose consent is valid for the examination? Can I get your comments on the chat? I hope you understood this scenario. So whose consent is valid? Can I take the child's consent? Okay. 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 Can I get some more? We have a divided house now. Whose consent to take? Yes, this child is only 10 years of age. So whatever 89 and 90 IPC we discussed in the previous case that doesn't apply over here because the child is less than 12 years of age. So the child's consent cannot be taken. The next alternative is the parents. Okay, in this case, should I take the father's, because a couple of you had mentioned the father's consent. So here, the if you look into the case scenario, the child is afraid whenever she sees the father, and the father is also suspicious of your procedures. So, would it be appropriate if I take the father's consent? Somebody is also pointing it out. Father could be the culprit. Is it the job of the doctor when there is no history given that the father is the culprit? Should we get into an investigative angle and try to put or judge somebody whether they are the accused? So definitely not. Let's restrict ourselves to the therapeutic care. We are not the investigating authority over here. The situation seems like the father is suspicious of your procedures. Father need not be the culprit alone. The possibility is there, but it's not definite because we don't have history on that. It could be a overprotective father also who is now trying to protect the daughter and is not having any faith with any of the other stakeholders, including the doctors. So that could be the reason for suspicion of the procedures. Somebody may ask, why is the child afraid of the doctor? So it could be one of the commonest thing which happens in an Indian scenario is victim blaming. And in this scenario also, the parent, including the father, might have scolded or blamed the child, and that could be the reason why the father is the victim is afraid. Another scenario also, so this is something which we need to be very careful while we deal with children, and as pediatricians you are well aware. So because the sexual violence has got a lot amount of social issues, the moment somebody reveals that there is a sexual violence in the family might have withdrawn from this or the community. They may be trying to be debating on it, or they may be looking at honor being lost. So the child is also a mute spectator of the things which are happening. So opposed to this assault, the child may look at the reactions of the family, and as a result of that, the child may get frightened. Oh, something big has happened, something untoward has happened, and that may be also the reason why the child withdraws from the situation. That could also be the reason why the child is afraid. So we have to look in all angles and not look only the father could be the culprit. Yes, I don't deny that could be a possibility. The father could be the culprit. But in this scenario, when the child is not comfortable with the father, can I explore to seek consent from the mother? And in this scenario, we have both people coming in front of you. So parents are there. So we should explore the possibility of seeking consent from the mother. But even in urban situation, or even in all our practices, we toe in line saying that generally when the father is there, so we don't even look at the mother for seeking consent. So in a male dominated society, so the power rests with the male member, and that's how I have pointed it as gender issues over here. So we need to look whether if the father is the culprit for hypothetical situation, we look at that. So is that father going to consent for your medical examination? Definitely not. So then are we acting in the best interest of the child? So we should always look if there is a possibility that the mother is there and the father is not cooperative in your situation, or the child is not comfortable with the father. So explore the possibility of seeking the consent from the mother. So that is something which we have to keep in mind. I hope we have looked at all the issues.
One doubt.
Yeah, please.
Since the father is suspicious, can we refuse examining the child? Because the
Father
is suspicious of the doctor's procedure.
Yeah.
So can you refuse? Because when the patient or the relatives are not having a confidence, we can refuse.
Yeah, that is the reason why I told we have to look in two angles. A straightforward answer would be father is not supportive to my examination, so why should I carry out? The other issue, as we had in the chat also, if the father is the culprit, in that situation, definitely father is not going to be cooperative, or father is not going to be comfortable with the examination. So as child rights ambassadors, so what would be our role? See, we are not going to look at as an investigative officer trying to find out whether the father is the culprit or not. The angle what is required by us to do is how we look at the best interests of the child. So that is the reason I pointed out, when you have both the parents coming in, so could you not seek the consent from the mother, so to gain more by your medical examination, and then you can find out why is the father suspicious of your procedures. Many a time we do, as you pointed out, if the father is suspicious, instead of going or exploring the mother, whether they give consent or not, we are very happy saying that we document an informed refusal. And we always argue out saying that the father did not or is suspicious of my actions. So if we toe that line, then we may not be acting in the best interest of the child. So that's the reason why I pointed out we have to be kept open, and we have to challenge this gender issues which are there in the society. And if we have to act as custodians of the child rights, or to act in the best interest of the child, so we need to explore all possibilities what we can do, instead of just picking up informed refusal. I hope I have answered your query. Can we move ahead?
Yes, yes.
Okay. The next case is a 15-year-old girl. Okay, we'll come to Srivatsava's question in this case scenario. So a 15-year-old girl had eloped with her boyfriend and became pregnant with 16 weeks of gestation age. So father refused to consent for MTP. What should doctor do, and whose consent to take? So it's a 15-year-old girl. She is 16 weeks pregnant. Father is refusing to consent for medical termination of pregnancy. What should you do, and whose consent is required? Can I get your answers? Is it tough? I'm yet to get any answer. Even if it's wrong, please put in your comments so we can have a discussion. Okay, I have a couple of answers. Can I get some more? Okay, there are three answers pointing towards the child, but I'm sorry, the child's consent is not valid in this situation. Why is it so? The question in front of us is not medical examination. The question in front of us is medical termination of pregnancy. As I pointed out earlier, 89 and 90 IPC, wherein it points at 12 years is enough, would apply for non-invasive situations of a mere medical examination. In this situation, we have the termination of pregnancy, which would be an invasive procedure. Somebody may argue out, okay, I can do MTP even with medical abortion. Even the latest amended MTP law also allows medical abortion only till 10 weeks of gestation. So at 16 weeks of gestation, there is no medical abortion legally possible. So what you have to do is only a surgical abortion. So surgical abortion would be an invasive procedure. And in that scenario, the girl's consent, because girl is just 15 years of age, so only above 18 years of age, they can give consent. So as the girl is less than 18 years of age, so her consent would not be valid. Now, the next alternative, whose consent would you take? So here are the parents there. Only father is there in the case scenario. We don't have the mother, but the father is refusing to consent. As Ashok, I think Dr. Ashok has pointed out in the chat, if the mother is around, but here in this case, the mother is not there. So would it be appropriate for us to explore the possibility of finding the mother? And if you can get the mother's consent, the issue closes there. Like what we discussed in the previous scenario. If you can get the mother and the mother consents for that procedure, the issue closes. But in this case, if you are not able to get the mother and the mother's consent, then you are left only with the father, and the father is now refusing to consent. We were just discussing in the previous case also, we all should look at the best interests of the child. So when we as therapeutic carer are looking at the best interest of the child, would it be a responsibility of the natural guardians also to act in the best interest of the child? yes, obviously the natural guardians, the parents also should act in the best interest of the child. But in this case, the father is refusing to consent. Whatever be the context, why, whatever be the background. So in this case, the father could be refusing to consent to teach a lesson to the daughter. So that's what had happened in this case scenario. The father wanted to teach a lesson to the daughter because the daughter had eloped with the boyfriend. Now, how do we approach such scenarios? If the father is not acting in the best interest of the child and MTP is supposed to be done in this case, so what should we do? Uh, so, can anybody give out what should be done after these clarifications? The father is refusing. One option is to counsel the father. So the counsel the father, the need for MTP, how that would act in the best interest of the child. If the child risks the pregnancy, she's still 15 years of age, what are the risks of a teenage pregnancy, how that may be not be in the interest of the child's health. So these have to be discussed. And in spite of that, if the father still refuses to consent, then we need to explore other possibilities. One of the possibility is if whether the panel of the doctors who are working in the hospital, who are not part of the therapeutic care, can they be asked for consent? So this is nothing new in multi-doctor hospitals. Particularly, we seek consent from the administrative doctors. It could be the medical superintendent, it could be the resident medical officer, it could be the chief medical officer. So we generally ask these people's consent, and if they also look into the scenario and act in the best interest of the child, and if they consent, so that consent is valid. But in a scenario wherein you are a single doctor and you don't have any panel of doctors, or if you have a panel of doctors but you can't bring them on board for seeking consent, or you have a multi-doctored hospital but the panel of doctors refuse to give consent, or it is not possible to arrange for them, so then what should be done? So in such scenarios, somebody has pointed out as court, but I beg to differ. Court is not the answer. We have another provision under the Juvenile Justice Act. We have the JJ Act looking at two positions. One, a child in need of care and protection. The other, looking at child in conflict with law. So, for the child in need of care and protection, the Juvenile Justice Act points out that Child Welfare Committee, a quasi-judicial body, who is bestowed legally the power to look at child in care, need of care and protection. The other arm in conflict with law would be dealt by the Juvenile Justice Board. So if the natural guardians are the people who are expected to act in the best interest of the child, if they are not taking care of that, then we need to explore the possibility of the Child Welfare Committee. And in such scenarios, the Child Welfare Committee would appoint a guardian, and that guardian would act in the best interest of the child. So the law is very clear. If the natural guardians are not going to act in the best interest of the child, the custody of the child gets transferred to the Child Welfare Committee's appointed guardian, and that person can seek the appropriate steps. I hope I have clarified the scenario. Exactly the same thing happened in this case also. The CWC were informed through police. At that situation, the father consented for the medical termination of pregnancy. The medical termination of pregnancy was done, but now father wants the products of conception to be sent for further investigations. But the girl says that she does not want to implicate the boyfriend with DNA analysis of the products of conception. So what should the doctor do? Should you subject the evidence, whatever you collect from the body of the girl, whose consent is valid for you to send that examination, whether it is the girl, because from her body you have taken it, or it is the father, because on whose consent you have done that procedure and taken the evidence. Can I get your answers? Should you toe in line with the girl so that the girl's consent is valid? Or should you toe in line with the father because on whose consent you carried out the MTP? Okay, I find a couple of answers. Can I get some more? I hope you understood the question. Okay, there are three answers. All of you are pointing towards the girl. Yes, that's what we have to look. If you look into the background of the previous case scenarios, we were looking at the child. So a child about 12 years can consent for medical examination as well as for the investigations what are done through part of that medical examination or the consequence. So the same thing applies over here. For a procedure of the MTP, she was not legally appropriate or of the age to consent. But nothing prevents her from, because she is above 12 years of age, to carry out the medical examinations, whatever has to be done out of the evidence which is pulled out from her body. Exactly in this scenario also, we had also looked at the girl's consent, and when she was not agreeing, we had documented informed refusal. But the father was threatening to use section 41 of the POCSO. So what is this section 41 of the POCSO? In the previous scenario itself, I was pointing it out. POCSO was a hurriedly brought out law just to show the reaction by the legislature saying that they are protective to the child. Because it was hurriedly brought out law, there are certain issues which needs further amendment or clarification, and one such section is section 41 of POCSO. Section 41 of POCSO says that whenever a medical examination carried out, either with the consent of the parent or a person in whom the child trusts, so then that would not be construed as an offense under POCSO. You may argue out how medical examination will become an offense under POCSO. See, for which we have to understand the earlier definition of rape. The earlier we were looking at only forceful penovaginal intercourse. But now the definitions got changed in 2012 when POCSO came in, and 2013 when the IPC got amended. Now it's no longer only forceful penovaginal intercourse, even penoanal, peno-oral intercourse is also there. It's not only penetration by penis, even penetration by body parts like fingers or any part of the body, or penetration by body, the objects into any of those orifices is also constituted as an offense under that. So, if you look into medical examination, we are also trying to use certain objects or instruments or certain times fingers into some of those orifices. So, it should not be, the medical examination procedure should not be construed as an offense under POCSO. So, that was the objective by which the section 41 was initially construed. We have a corresponding section even in section 375 IPC, wherein we have the explanation 1, which also says the same, saying that the medical examination should not be construed as rape. So you may argue out to then what is the problem? The problem is whenever parents don't consent for the medical examination, there are a section of doctors who feel saying that we cannot do this examination. So that would be a defensive approach. If you get carried out by that defensive approach, then you would not be acting in the best interest of the child, and you cannot be the custodians of the child rights. So this is the step which, as custodians of child rights, we have to take over. We are asking for an amendment to section 41, because whenever the parents themselves are the abusers, obviously they are not going to consent for the medical examination. So they should not misuse the law against the doctor. So we are asking, say, a sort of an explanation to this or a proviso to this law, but yet we are not successful. So we need more and more people to join, so that we can all pressurize the government for an amendment to section 41, saying that this would not apply whenever the parents themselves are the perpetrators, or there is a suspicion that they are perpetrators. So I hope with that we have covered all provisions of this case scenario. We move further. Sexual assault victim approached a doctor for getting an MTP done post assault. Doctor had mandatorily informed police and then proceeded in conducting the MTP. Police have issued a notice to the doctor alleging that the doctor should have waited till the police arrived before conducting the MTP. Is the doctor wrong or the police wrong? I hope you understood the question. MTP is being done. So the doctor has mandatorily informed and then carried out the MTP. But the police is insisting, saying that you should have waited till the police arrival before you carried out the MTP. Who is wrong? And they have issued a notice now to the doctor. Okay, we have a divided house, but more of people are saying the police is wrong. Yes, the police is wrong. Why? What does the mandatory reporting law say? Mandatory reporting law under POCSO is section 19, under the CRPC is section 357C CRPC. Both of them say that mere information is enough. So the moment we inform the police under mandatory reporting law saying that I am being caring a sexual violence victim, either of sexual assault or of rape, and you have informed them, so you have complied with the mandatory reporting provision. Then what is the problem? Why is this police insisting on that you should have waited? So we have to answer in such scenario to the notice saying that you have mandatorily reported and you have complied with whatever are the legal provisions. And you also have to point out, if you wait for the police arrival, so there could be a possibility that this could be a threatened abortion. And in a threatened abortion, you waited till the police arrival, and to your bad luck, if the lady either went into complications or even died, then the same police will come back and ask you, saying that you are the doctor, you should have cared, why did you wait for me? So the therapeutic care is the domain of the doctor, and we are the best persons to judge that. So we need not have to answer or wait for the police arrival, because mandatory reporting don't ask for that. It only says we have to provide information. Uh, uh, then what should be, why is the police insisting on this scenario? Police also, in an Indian scenario, we don't have separate crime police. They are also working for law and order. They are also busy in their own aspects. The police could be waiting for collecting the evidence and forwarding it to the forensic science laboratory. So in such a scenario, so what would be the practical solution? By mere informing, you have complied with the legal provision, but practically how to work with the police? So we need to always inform, if you are doing a procedure like MTP and if you are collecting the products, so you should communicate to the police at such and such time I am doing an MTP and the products would be collected. And depending on the hospital where you work, what is the facility for you to store that products of consumption? If you are working in a small clinic or in a PHC, you may not have refrigeration facility. So you should say that my duty ends at such and such time. If you don't collect within that time, I may not be able to keep custody of those things. If you are working in a bigger hospital, depending on the facilities available or to what extent you can carry out the procedure. In that context, you can always keep the police informed. And beyond that, also, if the police does not come and collect the evidence, then you can always you can inform their higher ups and take an appropriate action. I find one of the chat coming out saying that MTP is not an emergency, so doctor can wait. Yes, all MTPs are not an emergency, so you have to therapeutically look at what is the scenario. I told saying that if it's a threatened abortion, yes, then it becomes an emergency. If it's an incomplete abortion, yes, then it becomes an emergency. Many a time in sexual violence cases, people might have attempted various means, and on failure of that, may approach a doctor for completing the abortion or for a proper medical procedure. So that decision would lie with the doctor whether the MTP in front of you is an elective one or an emergency one. So accordingly, you do it. But in this case scenario, the police is wrong, insisting that the doctor should have waited till the police arrival. So that is not legally required. So I hope I've answered all the queries related to that. Then we move to the next scenario. A childline activist who came along with the sexual assault victim wanted to witness the medical examination being conducted, but the doctor denied permission and asked her to stay out. Is the doctor correct? What aspects should doctor consider before arriving at the decision? I hope you understood the question. A childline activist wanted to witness the examination, but the doctor denies the permission to that childline activist. So is the doctor correct? Should you allow a childline activist to witness the medical examination? Can I get some more answers? I find one answer which is there, doctor is correct, but unfortunately, okay, two answers. Okay, the doctor is wrong in this scenario. The doctor is wrong in this scenario, and that's what is the current law. So according to section 27 of the POCSO, things have changed. Things have changed. Now what has happened is, according to section 27, whenever you are carrying out medical examination of a sexual assault victim, whenever a parent or a guardian in whom the child trusts expresses interest to witness the medical examination, then you as a doctor has to compulsorily allow that person. This is the change in the law. Why is the law changed? Because the law looks at the best interests of the child. If the child is in a trusted company, that is either the parent or the guardian in whom the child has a trust, the child may cooperate and you may be able to do more for the therapeutic care of the child. So that's the objective by which the law looks at it. And in this situation, you may argue out it is not the parent or the guardian, it's the childline activist. Why should I allow the childline activist? See, Childline is an NGO which is working across many states. 1098 is its number. 1098, if you ask any child, or most of the children are now familiar. Many a time for a sexual violence, the child might have dialed the childline activist, and the childline activist may be the first person in whom the child has disclosed. There is a rapport which is already established with the childline activist. In such a scenario, the childline activist would fit into the position of the guardian in whom the child has trust. So if such a person is expressing an interest to look for the medical examination or be witness to the medical examination, where the child is comfortable with that person, so in such a scenario, you cannot refuse. The law goes further saying that if such parent or a guardian is not available, then it would be the duty upon the hospital to provide one. So the hospital has to look for a female person who would act as a chaperone there. But the requirement is we have to sensitize all our staff members so that in such a scenario, we are going to provide a person, a female witness over there, who the child should be able to gain trust. So if we are sensitive, then only that possibility exists. So that is the scenario. It's not only enough for us to become sensitive. So we need to train all our hospital staff also to fulfill this possibility wherever it exists. Then the next scenario, a minor boy was found molesting another minor girl in the school. The parents of minor boy approach you as a doctor. So what should you do? I hope you understood the question. A minor boy is found molesting another minor girl in the school, and this is the parents of the minor boy get aware of this, so they approach you as a doctor. So as a pediatrician, they have approached you. So what should you do? Can I get your responses? I hope you understood the question. So what should we do? Is it getting tougher? Should I give clue? Okay, okay, okay. Yes, mandatory reporting applies. POXO doesn't look at who is the accused. Accused could be an adult, accused could be a child, accused could be of any sex also. So mandatory reporting applies. Yes, yeah, you are correct. Yes, we have to mandatorily report. Now, counseling. Yes, counseling is required. Counseling is required. Somebody has pointed out we should also counsel or contact the minor girl also. Yes, that would be a best approach. But if the boy is the one which is in front of you, so first you need to counsel them. Now, by mandatory reporting, am I trying to criminalize the situation? Is a doctor having any choice in that? Could this act what the boy is doing could be an age appropriate sexual curiosity in a child? Yes, we all know the developmental pediatrics wherein age appropriate sexual curiosity and sexual behavior across the children also, so we consider something as normal. But the moment somebody is looking at this behavior, so should you criminalize that? So POXO doesn't look into the age-appropriate curiosity. POXO tries to criminalize all sexual activity less than 18 years of age. So we need to be bringing out this issue during our counseling, that you have no choice but to mandatorily report to the police, but you are there trying to act in the best interest of the child. As somebody pointed out, saying that if I try to gain the history that who is the girl whom the child has molested, and if I try to call them when they are not coming to you, would it amount to investigation? Yes, that's what I pointed out initially itself. If the boy and the boy's parents are the one who have come in front of you, our job would be to first counsel them. And in that case, again, we have to look out if it's an age appropriate behavior, but again, we need to give out the provisions of the existing law and how it tries to criminalize all this behavior. And in that context, so what should be the approach of the boy in future? And so those aspects have to be kept in mind in counseling. I did not give the age of the children here. So again, it would be getting challenging if you are looking at 4 years, 5 years, because we receive so many cases nowadays that a 5-year-old kid is trying to do this sort of a sexual act with another. So in such scenarios, we also have to remember. So directly blaming the boy, yes, you have to look whether it is the boy is the accused or what. So the Juvenile Justice Act looks at it as child in conflict with the law. So both the children need counseling. So in such a scenario, you pointing it out that the boy is the accused, girl is the victim, may not be an appropriate action. And we have to be sensitive in approaching this sort of scenario. Many a time we find the school also getting apprehensive and they contacting you as doctor, and what should be your approach. So in such scenarios, again, you may have to have an awareness issue when you are dealing with these children. But again, age appropriate. So whether you are dealing with what sort of, we are dealing with a teenager, things may be easy to communicate. But when you are looking at people less than say 10 years of age, so it may be quite challenging. And another scenario you have to keep in mind, why is this boy trying to do such an act which amounts to molestation? So one more angle which you have to keep in mind, whether this boy is a victim of pornography, exposure to pornography. And in such scenario, the child may be just enacting what they have witnessed in the either in a pornographic situation. So before you put a point or point fingers at the boy as the accused or in conflict with law, so if the boy is a victim of exposure to pornography, then where does the boy's position stand legally? Because of the exposure to the pornography, now the boy is trying to enact that. And how should you sensitively look at these sort of cases? What we are supposed to do is therapeutic counseling. What we are supposed to do is therapeutic counseling, and don't jump into it even if the police requests you to ask, because one of the common thing which the police point out is doctor, please can you find out whether the child is speaking the truth. See, that is not our job. We are not part of any investigation. We are only a therapeutic carer. The counseling what you are doing is for healing process and not for investigative process. So we should be the ambassadors for therapeutic counseling and never accept to become forensic counselors or trying to probe for the truth. And once you try to get into the investigative angle, then you are not acting in the best interest of the child. Okay, the next scenario is a 17-year-old boy approaches you, the doctor, for treatment of STI and also asks you for contraceptive advice for himself and his partner. On probing about his partner, you found out that he is in love with his lady teacher, 19 years old, at college for last 2 years, and they have sexual relations often. What is your approach towards the boy and the teacher? I hope you understood the question. It's a 17-year-old boy who has come for you for advice on STI and contraception. On probing, you find that the partner, who is a lady teacher, who is now 19 years old, but there is a history given saying that for last 2 years they had sexual relations. So what should you do as a pediatrician? Okay, okay, okay. Any further views? We should not forget we have a mandatory reporting provision, and we first have to mandatorily report whenever you find any issue related to sexual violence. Mandatory reporting takes precedence, and first you have to mandatorily report. Yes, parallelly you are supposed to also counsel and treat. That's what most of you have advised. Counseling and treatment is required only for the teenager, or whether it is required for the teacher also. Remember, this relation started 2 years back. So that means at that time the teacher was also a minor, less than 18 years of age. So this is something which we have to keep in mind, that the child sexual offense is a complex issue. Uh, Ashok sir, how long I have time? Can I take another 5-10 minutes? Hello?
Okay, sir, you can take, no problem.
Okay. So, because one of the expectation out of this was what is medical evidence? There are 5 types of medical evidence which we commonly get out in all these sexual violence. One is trace evidence, the other is injuries, the third is STI, the fourth, if there is a pregnancy, then its complications, and evidence of treatment. So as doctors, we should look for these 5 types of medical evidence. The trace evidence depends upon the sexual crime, whether it's a penetrative and non-penetrative, whether penis is involved, whether penis is not involved, whether ejaculation occurred, so whether there are injuries. Accordingly, you may find semen, spermatozoa, blood, or lubricant, or fecal matter, or likewise. But again, you have to remember this trace evidence doesn't remain forever. If there is a delayed examination, if there is a post-assault activities like washing, douching, bathing, urination, and all, this trace evidence goes. So you may find the trace evidence if you are doing an immediate examination or an early examination. The next type of evidence is injuries. These injuries could be of as minor as an abrasion to even the fractures or firearm injuries, depending on the scenario. Again, it's not necessary that in every case you find injuries. Literature speaks out less than 1/3 of cases. That means less than 33% of the cases only you find injuries, and in the remaining situations you don't find injuries. That doesn't mean it's not a sexual violence. So even though it's a sexual violence, in 2/3 of cases you don't find injuries. This is something which we have to keep in mind. And even if there are injuries, they may not remain forever. If there is a delayed examination, the injuries start healing and that injury may not be visible. The third type of evidence is sexually transmitted infection, and that would go with saying that if one of the partner, either the accused or the victim, was having a STI, so in such scenario, there is a possibility after the lapse of the incubation period that the infection could be seen in the other partner also, other person also here, and you doing 2 tests, one as immediately as possible and the other after the lapse of the incubation period. If you can pick that, so that would be a good corroborative evidence to prove sexual violence. The next would be pregnancy. Again, look out, boys will not become pregnant. That doesn't mean every girl or a woman with sexual violence will become pregnant. So this is something which the courts may ask or the other stakeholders may ask, because they are not aware that all unprotected sex may not lead to pregnancy unless until it is conducive atmosphere, it is corresponding to the ovulation time and the conducive atmosphere for fertilization, then only there is a pregnancy, otherwise it may not occur. So if the pregnancy continues till delivery, then you have the fetus. If not the termination, then the products of conception act as medical evidence. The fifth type of evidence is evidence of treatment. Today we are looking at compulsory treatment. So in that scenario, so if you have picked up history of a pain in some part of the body post-assault, your examination picks up tenderness at that site. You have prescribed an analgesic. There is an independent proof of consumption of that analgesic or a prescription or a pharmacy slip. So wouldn't all these indirectly prove that pain post assault? So definitely, yes, it will prove that there was pain post assault through your documentation, one in your history, next in your examination, third the for prescription slip, fourth the pharmacy bill, and likewise. Similarly, if you pick up infection in the case history, then in your examination, then the prescription of an antibiotic or a consumption of an antibiotic. Similarly, your history picking up depression, your examination finding depression signs, then your prescription of an antidepressant and the consumption of an antidepressant. So this is something which we are going to find because of the compulsory treatment very often, rather than the earlier explained four evidences. That doesn't mean they are not there. See, the trace evidence, injuries, STI, and the pregnancy and its issues, if they are there, they are a very good evidence. But if they are not there, then that you can't negate that there is no sexual violence. But what is important is in every case, you are going to pick up evidence of treatment. And it is a good approach that all of us as healthcare providers should be able to bridge this new medical evidence, which is easily available because of the compulsory treatment in the adjudication of sexual violence. So as I already pointed out, the medical evidence may not remain forever, and it all depends on many factors. So if medical evidence is not available, or it should not mean that offense did not occur, it's only at the time of examination we could not find. So two more cases, or we will try to figure out, or you can decide when to stop me. Otherwise, I have a couple of more cases. So this is a case of a 17-year-old girl who is in relationship with her classmate boyfriend. When she failed to have her menses on a regular due date, she got anxious and visited her doctor. Worried that she was already pregnant, she discloses to the doctor about her several sexual relations with her boyfriend. She also discloses that she's also worried about the conservative parents, how they would react, whether she could continue her studies. So doctor is unsure of the next step, whether to inform the girl's parents against her wishes, whether to inform police, whether to counsel the girl about safe sex, advise about pregnancy and its care. So what should the doctor do? Can you advise the doctor? Okay, yes, one of the quick answer which I got, yes, mandatory reporting. So all sexual activity less than 18 years, you have no choice, you have to mandatory report to the police. Yes, we are as a therapeutic carers, you are supposed to take care of pregnancy, you are supposed to take care of the if emergency contraception, STIs, abortion, psychological counseling, and likewise. So informing parents, it would be always better if the child is about 12 years of age, depending on the consent of the child you need. So would it be possible in an Indian scenario wherein the parents because many of us as pediatricians always look out, should I toe in line with the child or should I toe in line with the parents? As the custodians of child rights, we should toe in line with the child and act in the best interest of the child. But you need to educate the child, saying that how that would help in getting the support of the parents, and how that would help in a long way in trying to recoup from this whatever are the consequences. So keeping the child in confidence and informing the parents is something which we have to always explore for. I hope with that we answered. We quickly look at a couple of more cases.
One doubt, please.
Yeah, yeah.
You are reporting to the police and you are reporting not to the parents. So
Yeah.
is it a paradox?
Yeah, see, we are for two different contexts we are doing it. We are reporting to the police because we have a mandatory reporting law. We are not reporting to the child parents because we didn't get consent from the child, because the child here is 17 years of age. See, if I lose the confidence of the teenager, I am looking, see, we are looking as doctors how to undo the health consequences post sexual violence. See, our objective is to look at the therapeutic care of the person who is in front of us. By informing the parents if my therapeutic care is going to get affected, if the child is not going to participate in the therapeutic care, see, then I have not done anything. I might have done more harm to the child because I lost the opportunity. But I don't want at the same time to do something illegal. When you are looking at the child above 12 years as a person who can consent for their medical examination, so definitely we are able to look whatever are the information which you gather from that medical examination would also be required to be seeking consent from that person. Okay. So what is the police likely to do in this case? Yes, now the police are also being sensitized about their approach. So they are also trying to look at how to handle the adolescents in a sensitive manner. So if you try to criminalize all the activity, we may not achieve great results, because in the name of trying to punish the accused, we have no position to punish the victim. So we have to keep that always in mind. In the name of punishing the accused, we cannot get into the punishment mode on the victim. So that is something all the stakeholders, not only the doctors, including the police, including the court, everybody has to keep in mind that we cannot punish the victim. Okay, next couple of cases. School counselor, sir has pointed out, especially if it is consensual. The consent doesn't arise because less than 18 years, the girl doesn't have a right to consent for a valid or a legally valid sexual act. So school counselor receives a 11-year-old boy for counseling that he is unruly, poor in academics, depressed. All the changes are observed in the recent past by the class teacher. Counselor, after several sessions of counseling, gained trust and confidence of the child. After assuring confidentiality and support, the boy then reveals to the counselor that the grandfather who is staying with them for last 4 months repeatedly abusing him through anal penetration. Boy pleads with the counselor not to inform anyone. Counselor is unsure of the next step, whether to inform boy's parents against his wishes or whether to inform police. So can you help out the counselor? What should the counselor do? Okay, one immediate answer is inform police. Should I inform the boy's parents? Here is a 11-year-old kid. Okay, one, yes, mandatory reporting. Next, here we have a child less than 11 years of age. So the child may not be legally valid for consenting for the medical procedure. So obviously you have to bring the parents or the guardian over there. But again, why are we doing all this? So mandatory reporting as well as informing the parent would be in the best interest of the child, to prevent further abuse of the child, to seek therapeutic care of the child, to prevent further abuse of other children by the perpetrator. So we need to have the trust of the child as well as the parents, and we need to always look at the long association. See, if you try to narrowly look at this problem, saying that my job once I mandatorily report is over, see, in that approach, we may not be acting in the best interest of the child, because the health consequences post sexual violence requires a long term support, and as pediatricians, we need to be there to help those people as long as they need that. So that's the therapeutic care, including psychological counseling. uh, Next is Ashok sir, you can stop me whenever you want. 17-year-old Indira is brought by her husband to psychiatrist for treatment for mild mental retardation. Psychiatrist confirms mental retardation, but in addition also found that she is pregnant by urine test. Psychiatrist is unsure of the next step, whether to inform police, whether to inform the husband that having sex with minor wife is crime, whether to inform Indira that she is pregnant or that she is mentally retarded. So here is a situation of mental retardation in front of you, who is pregnant, brought by the husband. So what should be the doctor's approach? Okay, can I get your answers? Here we have to look out because the person is only 17 years of age, so it comes under uh, uh, situation of POXO, because any sexual activity less than 18 years would be an offense of POXO. Even the exception under the IPC 375 was struck down by the Supreme Court in 2017. It is struck down by Supreme Court in Independent Thought versus Union of India. It put out saying that married, unmarried has nothing to do. All children less than 18, if there is any sexual activity, then it would be an offense under POXO. So we are stuck with providing therapeutic care. Here, purposefully, I brought in mental retardation. So what would be the approach? So by doing mandatory reporting, so would the husband go behind the bars? So when you are looking at mental retardation who needs a support and care, so should you lose the only support of the husband? So should you act socially or should you act legally? So your job is to act legally, but at the same time try to explore what are the support system available for taking care of this mentally retarded person. So proof of age, as pointed out by Rajendra sir, becomes very important. And if she continues to be 17 years of age, so you have to be very careful because POXO applies. Even if the person is above 18 years of age, if somebody is mentally retarded, if somebody is psychologically abnormal, so again it attracts an aggravated offense and would attract higher punishment even under the IPC. Last two cases, 32-year-old Mahesh is seeking advice from sexual medicine therapist that he has problems in his sex life with his wife. On probing Mahesh, the sexual medicine therapist finds that as child, Mahesh was sexually abused by his father for several years. Mother, in spite of knowing all this, had continued to maintain silence. Mahesh was scared of sex even today. Should sexual medicine therapist inform police whether to only counsel Mahesh and treat his sexual problems? Mahesh is 32-year-old. Okay, I get the answer only to treat. I do hope others also. Could we get your responses? So would mandatory reporting apply? Yes, mandatory reporting doesn't have a limitation. Does it have any limitation? Say POXO law came into force in 2012. So we are in 2021. If Mahesh is already 32 years of age, and if as a child, so less than 18, so that means if you take 14 years, so definitely when the offense occurred, even at less than 18 years of age, POXO was not there. So the provisions of POXO doesn't apply. But what is the criminal law? Is there any limitation for a criminal law? I'm sure all of you remember the Me Too movement a couple of years back. And at that time, several people brought out several offenses which were there during their childhood also. So for a criminal law, particularly for a heinous crime, there is no limitation. It can be investigated at any later point of view. But in this case, POXO would not apply because at that time, POXO law was not there. But whatever was the criminal law for sexual offense at that appropriate time, so that would apply. So apart from that, you are supposed to provide therapeutic care. And in this case, even the mother was aware that the father is abusing the child, but the mother kept quiet. So that's again in a male-dominated society. Many a time, the mother may be dependent on the father, and the father could be the sole breadwinner. And many a time, the mother or the family members may still silently suffer and may not mandatorily report. And this is something which you have to always keep in mind what happens on to the victim if some trusted person is the abuser. Definitely the psychological impact which would occur would be many-fold than a stranger situation.
So this is the
Yeah,
last case?
okay. This and I will take one minute for each. Two cases are
Okay,
there.
okay. That's okay.
Okay, I will only discuss and close it. A
Yeah,
18
fine.
years, 4 months old lady presented to the nursing home for delivery of her full-term child. The doctor wanted to mandatorily report to the police, citing that she became pregnant when she was a minor. Is the doctor correct in action? Here, the doctor is mandatorily reporting when somebody is already beyond 18 years, 18 years, 4 months. But the doctor is correct here because it's a full-term pregnancy, but when the time the conception happened, the person was still a child. So POXO law would definitely look at that, and all sexual activity less than 18 years would become criminal, and the exception of married doesn't apply. The exception under 375 IPC is also now no longer valid, so it is struck down by the Supreme Court. The last of the case is doctor refused to terminate pregnancy of a rape victim aged 17 years who was 23 weeks of gestation age, citing that a court order is needed for MTP. Is this doctor wrong or correct? Can I get your quick response on this? A 17-year-old victim, rape victim, who is with 23 weeks of gestation, the doctor is insisting that a court order is needed. Is the doctor correct or wrong? I find Anne reporting it is wrong. Any other comments? Yes, in today's context, it is wrong because we have now the Medical Termination of Pregnancy Amendment Act of 2021. Even the rules got notified a couple of weeks before of 2021, wherein we have now new rules which are applying. So till 20 weeks of gestation, one doctor opinion. From 20 to 24 weeks, two doctors' opinion is allowed to terminate pregnancy in special categories of cases as per Rule 3B, which says that survivors of sexual assault or rape or incest is the first one which fits into our case, and that's how the doctor is wrong because as on date, so a couple of weeks back that was a different scenario, but we need to update ourselves because India has now adopted the special situation of Rule 3B for special categories, which includes minors, which includes survivors of sexual assault, rape, or incest. You also look what is the widened situation, change of marital status during the ongoing pregnancy. Somebody becomes a widow, somebody becomes a divorcee, then they can request, and that is also to be honored. Women with major disability as per the Rights of Persons with Disability Act. Mentally ill woman, including mental retardation. You found Indira's case also a little while before. Fetal malformation, substantial risk with incompatible to life if the child is born. Look, women with pregnancy in humanitarian setting or disaster setting or emergency situations as declared by government. If you look into the COVID pandemic, particularly during the lockdown, there were many situations wherein people suffered because they couldn't get the services of the MTP, because most of the hospitals were converted into COVID hospitals, and whatever were their rights were getting denied because the rest of the hospitals were closed because of the lockdown. So the major hospitals were looking COVID, the minor hospitals or lesser hospitals were all closed, and there were healthcare being affected. And definitely, if you look at all those things, there are several rights of the children which got affected during that time, and right to health, right to information, right to privacy, right to be heard are some of the issues which we always have to keep in mind when we look at child rights. I'm sure with the last 1 week wherein you have rallied behind all these, you are all the greatest ambassadors to look at best interests of the children. So thank you very much for your time, as well as I thank IAP Madhyakerala for giving me this opportunity. So thank you very much.
Thank you, Jagdish sir, for a wonderful presentation. I must tender an apology because we have very few audiences. I expected little more people, but I'm extremely thankful to Dr. Jagdish for giving a wonderful presentation. And any other comments, Dr. Srivastava sir? Any comments? Sir, I think you are not audible. Any problem with the?
Ashok sir, I think you have recorded my presentation. I would give my consent if you can use at any other forum if you feel this is appropriate. You can use that.
Thank you, sir. Thank you very much. Thank you very much.
Yeah.
Ashok sir, can I ask a doubt to?
Yeah, Maushami,
Jagdish?
I saw you. I saw you. Please open
Yes, sir.
your video. Open your video. I wanted to have your comment. Srivastava sir, we
Yes,
cannot hear you, sir. Sorry, sir. Maushami.
Yes, sir. Sir, Jagdish sir, this is
Yeah.
a doubt that I wanted to ask. Sir, is this collection of evidence now, has it been increased to 21 weeks, sir? Sorry, 21 days. That is 3 weeks for.
See, this confusion has arisen particularly because we have the Central Forensic Science Laboratory of the Chandigarh, which has come out with a manual. But what happens is, see, one exception situation of a scenario, like, see, clothes can be collected at any point of time.
So this is swab, sir. This is about.
Swabs again, see, one exception. See, there are exceptions. Whenever we make guidelines, we have to look into a pan-India approach or what is feasible approach. So we can't look at exception situations. Suppose if I'm looking out for a vaginal swab, there is a possibility of you picking up the sperm at the time which it corresponds to the cervical mucus secretion, which is thick. The possibility of you picking up the spermatozoa in the thick cervical mucosa is there. But how can you time out that in every case what you are looking out is that? See, the Central Forensic Science Laboratory has brought out that, but if you read those guidelines, it very clearly says you follow up all whatever the Ministry of Health guidelines are there. but it gives an advice saying that what is possible, how an evidence could be collected, and what is the documentation needed, and in such scenarios. See, the exceptions which they have given cannot be the order of the day. If I start collecting in every case till 21 days, the FSLs will, forensic science laboratories will come back with more negative reports, because obviously beyond 5 to 7 days, the possibility of you picking up that trace evidence doesn't arise. So you have to look out. See, an exceptions cannot be a part of the guideline. If you read, whether it's a WHO guideline, whether it's a national guideline, they are to be made for a pan approach or a large approach. You cannot look for exceptions and make guidelines over there. I hope I have answered that.
Yes, sir. Thanks. Thank you, sir. So the other thing I wanted to ask is, like for cervical smear, the use of speculum, is it allowed only for collection of evidence, or only if there is an indication, medical indication to use the speculum?
See, generally we don't pick speculum or pervaginal examination less than puberty. So we don't want to alter the anatomical positions or situations. But nothing is a bar if it is done in the interest of the person. So whether if it is in a therapeutic interest, so whether there's a bleeding injury, whether there is an infection, whether there is any foreign body, if you are trying to look for those in the therapeutic interest of the person, there is no bar in using the speculum or vaginal examination. So you have to justify the need for it. Why do you need a cervical swab? If it is justified in that scenario, so then you can carry out. See, the law is very clear. The best practices across the globe are also very clear. So you are the best person to judge the therapeutic interest. And if the therapeutic interest take precedence, you can do any procedure. But you cannot be the investigative person, and you cannot try to act forgetting our primary role of therapeutic care. So that's the battle which we are fighting it out. There may be difference of opinion. Some of our own colleagues may not agree on that, but that fight continues, because as doctors, our first role is therapeutic care, and then we assist the judiciary or the criminal investigation through our therapeutic care. We can never become part of the investigation, forgetting the therapeutic role.
Thank you so much, sir. Thank you for your inputs and your thoughts.
Okay, thank you.
This type of discussion based on these case scenarios is extremely good, because we were all, at least I was all, alert at all time. And
Yes,
all those who attended will always be alert, because so Dr. Ashok Kumar should post the recorded program in WhatsApp, then YouTube, etc., so that it will be very useful. And with a comment also, just posting is not sufficient, just a comment of, so why it is good.
Okay.
Thank you.
Srivastava sir, your audio is okay?
Can you hear me now?
Yeah. Oh, yes, sir.
You're audible.
No, this is a masterly presentation. I have listened to Dr. Jagadeesh number of times, but believe me, every time it seems like watching a new movie, totally. And every time I learn so much. And my concern is that this knowledge should be known to many pediatricians, as many as possible. And IAP Kerala has to be congratulated. They have done the maximum for this. Our own people, Dr. Ajay said, and others, 2 years back, the UNICEF, they carried out many of the workshops, meetings all over the country. But I somehow wonder, what is the impact of all this? I'm sure, but we need to look into that. Dr. Ashok Kumar certainly has done very well for the cancer group, and I hope this will be continued. I again congratulate all the IAP Kerala people here, experts. Thank you very much. Thank you.
Thank you, sir. Thank you very much.
Thank you.
I think if there is no more questions, I think we will wind up saying once again, thank you, Dr. Jagadeesh, Dr. Srivastava sir, Over to Dr. Nimi for the formal vote of thanks.
Thank
Nimi is
you.
babysitting. Babysitting, sir.
It's 9:30, sir. At least I should handle one.
What's his
No.
name? Say hello to him. What's the name? Baby.
No, I should ask excuse. I'm really sorry. We have
No, sir, this
overshot
is
the time.
usual. I have 3 of this age, like 5, 4, and 3. So I should handle one at a time.
She is always one of the children is always part of our Zoom program.
Workshops. No, they will become pediatricians with more knowledge.
Really wonderful.
Thank you so much, Jagadeesh sir, for such a wonderful session. Like we have recorded it, and though the attendance was little less because we had programs all this week, and like we will publish it in our YouTube channel too. It's really useful, and thank you Srivastava sir for attending the full session, Nausimi ma'am, Shimi sir, Benoy sir who were there for the whole thing, and I thank Ashok Kumar sir for like arranging everything. He was busy throughout the week. Like I don't think he has slept well for this last week. Thank you so much for attending such a nice session. Thank you everyone, and good night.
Thank you all. Good night. Good night.